SJC-11553, Commonwealth versus Scott Steadman.
Okay, Attorney Kelly.
Morning, Chief Justice, members of this honorable court. On behalf of Mr. Steadman, I'm Brian Kelly. May it please the court. Mr. Steadman was convicted in February of 2013 under both theories of first-degree murder in the Norfolk Superior Court. We're asking this court to, in review of all this, the transcript and the brief submitted on behalf of the defendant, to exercise its power and grant Mr. Steadman a new trial.
We
We're
will,
also-
counsel. We'll read everything under our 278-33 rule. Your clients can be confident of that.
Thank you. We're also asking the court to review, as the court well knows, one of the big issues here for the defense is this forensic testing issue, and I'd like to address that first.
Can you, in the course of your argument, address the timeliness of this
Sure.
appeal?
Yes.
Thank you.
I'll talk about that first, Your Honor. We had filed, and I'm the attorney who filed that request in the lower court. As the court, so for two reasons, I think that the appeal was timely. One, we didn't get notice, and I put that in the affidavit that we filed. Secondly, under the COVID rules, under the standing order of the court, for those two reasons, we believe that the appeal was timely. I know the Commonwealth is disagreeing with that.
Do you think, regardless of the status of that appeal notice and its timeliness, that we can consider it under our 33E review?
Yes, absolutely. Absolutely. I think this is a basic fairness to the defense, is that, you know, one of the rules, and this is goes back forever. It's just, if you don't get notice, I don't know how you can appeal. So it really just came down to that for us. And obviously during the
When
COVID.
you say you didn't get notice, you didn't learn you lost the.
No.
Okay.
No, we didn't know. So that's the reason why I think the court should address that. This
Can I
particular
ask
issue.
one other question?
Sure.
Do we carve that out of I mean, I understand you say it's part of the 33E review, but does that mean you could lose your appeal but get the right to do the test? I mean, we would say we don't find any merit to the rest of your argument, but we think this is preserved and you should have had that. How does that read? Does that mean you lose your appeal, but you have the right to new testing?
When you say the appeal, do you mean the direct appeal?
Yes.
Yeah.
Yes, that's what I think. Yes.
Okay.
So in other words, I lose the issues on the direct appeal, but the court believes that there's substantive arguments on the testing, I think is what Your Honor is asking me.
Right.
Sorry. Yes, I agree. I think that's true.
When did you get notice of the decision?
Testing my memory here. I think it was in April or something like somewhere around. It was
Filed 30 days later or something?
right. I filed it basically as soon as I possibly could, once I got the notice. And my memory is completely exhausted on this issue. I haven't looked at this in a while, but my
But you
memory
said you
was,
submitted an affidavit?
I did
Okay.
with the motion to file it late, I believe. We filed an affidavit, and I know that's in the record here somewhere. But I can tell you, as an officer of the court, we didn't get notice. We didn't get notice. And as soon as I found out, I filed the notice of appeal. So if there's no other questions on that, I'd like to move on to the substantive issue about the forensic testing. As I'm sure the court can probably got a flavor of this particular crime scene. There was a lot of blood evidence. There was a 2/10, and most of the blood, it appeared from the photographs and the transcript, was centered around the victim's tent. But there was also some blood evidence that was from the trail. This was a crime scene that the two tents were sort of back behind this rental building, like a U-Haul, or I can't remember exactly what, but basically the trail leads out to a parking lot. And so there was blood evidence along that trail. And there was, so blood evidence in a trail of rocks. There was blood evidence in a sock. There was blood evidence on the Fuller's tent, who were two witnesses that testified at the trial. And obviously there was blood evidence in the victim's tent. So we were asking for the opportunity to test, I think it was those items that I just pointed out there. One of them was a footprint that was disclosed mid-trial in the victim's tent. So the court, I'm sure, has seen that transcript that the defense counsel made a motion for mistrial. There's a separate issue with respect to that. But during the trial, it was disclosed, there was this footprint. Unfortunately, the photograph was not marked for identification. So it's not part of the record, but so some question in my mind about whether or not I even have the photo, but we know that there was a photograph. We know that there was a footprint. We know that the tent itself is actually at the courthouse. So what we were asking the court to consider under Section 3, we believe we made the proper case. We believe we made we named all the things we were looking to test. We thought a reasonably effective attorney would do that in those circumstances under Commonwealth versus Wade. It's just the potential to demonstrate innocence. And I don't think that the standard, as the Commonwealth has briefed it, is hyper-technical. DNA testing happens routinely in these courts, and the court knows this. It's not the kind of testing that Wade involved, because Wade was a sexual assault case. And so I don't think that the submission was faulty in that regard. We were asking for what happens almost every single day in the courts of this Commonwealth. The state police swab something, it goes to the crime lab, a DNA profile is developed. So that's what we were asking for.
Can you address B5? That is Section 3, B5, what the reason the evidence was not analyzed yet? Is that, are you focusing your arguments on the fact that a reasonable attorney would have done that?
That was part of, I think that was part of the argument, yes, Your Honor. So there's different pieces of evidence, and I think that it's as I analyzed it and submitted it to the court, I think the Section 5 portion of it, if you're looking at the footprint, I think, as I understand that standard, it's applied, it's a lesser standard than ineffective assistance. It's a reasonably effective attorney. And I think the legislature did that on purpose. I don't think it's as high as a burden for the defense. And so when we look at that, obviously with the footprint, it's a difficult thing to apply to this case because it came mid-trial. But sort of setting that part of it aside, if you're applying this question, reasonably effective attorney. So we have a footprint outside of the victim's tent. It's in blood. So I think that the way I'm perceiving this, and when we look at Wade, would a reasonably effective attorney have done that? The answer is yes. For the blood trail, and I know the Commonwealth makes a big deal about the Bowden defense, that there is, because the defense attorney was successful.
I'm sorry to stop you, counsel. For the footprint, you want DNA swabbing of the footprint, or is it the visual inspection of the footprint?
We were asking for the visual inspection, and we had moved for funds for that, Your Honor. And, the visual I should just say that the visual inspection is by myself. I think the Commonwealth suggested that I could do it or somebody in my office could do it. I don't have that kind of expertise. I would need an expert, and that's why we moved for funds for someone to review that. And we, obviously, Mr. Steadman, being an indigent person, could not do that on his own without court approval for the funds. So that was another portion of the motion that we had made. If that answers the court's question, I'm going to move on to the other pieces of evidence in the case.
I understand. So you wanted to inspect the footprint that had blood in it, and the DNA you wanted done was on the trail.
Yes.
And just connect the dots for me. And so you're going to show somebody else's blood on the trail. Is that the idea?
That's the potential. And I think that's what the standard is, Your Honor. Commonwealth makes the case that this could be the victim's blood. It could be my client's blood. It could be Estabrook's blood. It could be a lot of things. I don't disagree. But the potential is what the standard is under Wade. And I think the potential is that it could be somebody else's. You heard from the transcript that there was another person.
So if you link that potential, assuming that it is somebody else's, how does that affect your client?
Well, I think
Exactly.
I'm sorry.
Just exactly, yeah.
I think if it demonstrates somebody else's DNA, let's say, if it's Estabrook's, it may not demonstrate anything. If it's my client's, it may not demonstrate anything. If it's Fuller's, it would demonstrate something.
Okay, what
right?
if it's a fourth person?
Well, you saw from the evidence that there was a motion for third-party culprit evidence in this case. The two convictions of Derek Royal, the Commonwealth says old cases, 1992, 1997, but they were very, very similar. He was there earlier in the day. He had an argument with the victim. It was pretty, in terms of timeliness, it was pretty close in time. And I think, not to get too far into Silva Santiago, but we're talking about those substantive connective links. And so if you double back to that, to this question about the blood, well, now we're talking. If that blood turns out to be his, and again, we're just dealing with the potential, I think there's a basis to think that we might get a new trial. He might at least be able to ask for one. So I think that's what the
Counsel, I noticed in the record, there is a transcript of a hearing with, I think, Judge Fay.
yes.
What was that hearing about? Was that the evidentiary hearing on the Section 3? Was that just oral argument on the Section 3? What was that?
I think Your Honor is referring to predecessor counsel's motion for the forensic testing. And I don't.
So that's not the present motion that we're talking about.
No, Your Honor.
Okay, thank you.
The predecessor counsel actually asked for, I think, more than 20 items to be tested. So when we saw that, I thought we should probably narrow it because I think that the potential needs to exist. And there were 105 items, I think, swabbed, and none of those items were tested at the crime scene, which, I understand the Commonwealth's position, right? There's a lot of blood here, and maybe it doesn't help their case, especially when you look at the transcript as a whole. But from the defense's perspective, I think under this particular statute.
But could that motion have been made? It couldn't have been made before the conviction, could it?
No, I don't think so, Your Honor.
But could you have asked for it in another way?
In other words, defense counsel prior to the trial could have tested that blood.
Yeah.
Sure, I think so. And here's the thing. If I was handling this case, probably. Because if you look at the evidence as a whole, we're looking at Lambert's testimony. He's the one that provides the knife. He's the one that testifies to the knife. I mean, he's got some problems, right? I mean, the transcript shows that the cross-examination is, pretty effective. But the problem with that testimony is it's corroborated by the medical examiner.
Right.
And the medical examiner's testimony is, I think, what corroborates that type of corroborative evidence is what, at least in my experience, I think juries really want to hear. If they have a witness that's got some problems, the corroborative evidence is what kind of seals it. And so, yeah, I think if it were me handling the case at the trial, I think I would have probably tried to, because I think the evidence is I wouldn't say overwhelming, but there's a lot of it.
Now, my understanding when that statute was passed is they were really thinking of the post-conviction period.
Yes.
And post-appeal period,
Yes.
probably. And so obviously you're in a somewhat different position because your appeal is still pending. Do you think the conviction is final enough for the statute if it hasn't been fully appealed? Is it really a conviction?
It's a good question. I don't know the answer. So the conviction happened in February of 2013. Yes, I think so, right? I mean, even though the appeal, I see what Your Honor is saying, the appeal's pending, is it final? I don't know.
I don't either. I don't know either.
How do you deal with the Bowden? Because counsel goes with the Bowden theory, right?
Yeah.
And it is extremely odd that they don't test any of the blood here, right?
Right.
That's just strange, right? I
Yeah.
mean, especially because we have two different fights. We have the fight from the night before, we have that fight. They don't do any sorting of the blood. They don't do
Right.
anything. So is it a strategic decision to stay away from that blood? Good chance it's all your clients. No. Now, or, that didn't work. That might have been good this time, but now we've still got 3A as a low standard to meet, right?
I understand. I see the Commonwealth thinks you can't have it both ways, right? You shouldn't be able to argue this at the trial, say, oh, there's no evidence here. They didn't test this. They didn't test that. Reasonable doubt. I don't think that's particularly effective in this kind of case. And I'm not saying it's ineffective to go this route. He got the instruction, but I just don't, in my reading of this particular statute, I don't think the defense has to live with the choices that are made by trial counsel and are stuck with it. As I read the statute, as I read this testing statute, it provides a basis for appellate counsel to look through the transcript, look through the record, and make the case that these items, by a reasonably effective attorney, should have been requested. And I think that's the.
But even though, as Justice Wendland was pointing out, you're really going on 3B5.
Yes.
So we do have to decide whether a reason, don't we do some of that in that reasonably effective attorney? Those choices. I mean, I understand you say it's a lower bar than ineffective assistance to climb over. But we still have to do that in 3B5 if you're relying on 3B5, right?
Yes. I don't disagree. I think that, but I think if you look at this as a whole, the transcript and the case, and as I understand, it's sort of an objective standard. It's not applied as is at the time. It's applied as I review it to the sort of how it looks now versus how it may have looked then is my reading of the statute. You're the ones that make these decisions, but that's the way I read it.
Can I ask you to address the third-party culprit evidence? And in
Yes.
particular, as I understand it, the fact that there had been a dispute between Mr. Royal and the victim came into evidence, right? And also the reason for that dispute, was that in evidence? And the only thing that you're asking that was excluded, I'm sorry, was Royal's prior bad acts, for lack of a better word.
So I think there are two issues. There's two ways you could do this as a defense attorney. One, you can ask, can we bring in the evidence of his convictions under Silva Santiago?
But just as a sort of to set the table, what came in was there was a dispute between Royal
Yes.
and the victim, and the reason for that dispute.
Yes.
That came in.
That came in.
And so what was excluded was the prior convictions.
Prior convictions.
Yeah.
Right. So I think there's two potential ways this could come into evidence.
Right,
I think
Bowden
probably the court
and-
knows where I'm going.
Yeah.
Yeah. So under Silva Santiago, these other acts, whether or not you get in the actual convictions or not, but at least the acts themselves, cross-examination on the detectives, I think under Bowden. And that seems to me like, it seems like to me that was an error. So even if you say, okay, the 1992 conviction's too old, the 1997 conviction's too old, even though they're remarkably similar in some ways, the 1992 conviction is different in the sense that the modality of the murder was different. It wasn't a stabbing, it was a beating, but a homeless person in an encampment. And then in 1997, a homeless person in an encampment. Now we have Mr. Royal there that day in a homeless encampment. He's got a motive in the sense that he's angry about these marijuana plants. There's also some similarities in 1997. They were arguing over property. They were arguing over, I think it was alcohol. And the 92 and the 97 incidents were different because they they both involved the person being tied up. But the 2009, Mr. Pratt's death, that didn't involve that. It was a stabbing. So I agree that there are some differences, but there are certainly some similarities. And so to answer your Honor's question, I think there could have been a cross on the detective that went to go talk to Mr. Royal, because I think they pulled his record. So that would have been a saving way to do that, is to say, okay, we're not going to let in the convictions, but you can cross him on, did you know that he had, this kind of action in the past? There could have been a way to balance out the age of that, but let in some of the information for the defense, because I think that really could have changed this case. And when we decide these, and when the court decides these, I think that's the real question. Could it have made some effect? Could it have changed it? And I think that, to me, as a trial attorney, I think that would be big. And so that's I think the error that was made there. Briefly, just about the hearsay issue with
I'm
respect.
sorry, is it in your brief? Because your time is up.
Oh, it is? Oh,
Yeah,
I'm
I
in
know,
the
time
red.
goes so
I
quickly.
didn't see that. Thanks so much. No, yeah, I'll just rest on the brief.
Thank you so much. Okay, Attorney Glennon.
May it please the court, Your Honor, Stephanie Martin Glennon on behalf of the Commonwealth, and we are asking this court to affirm the defendant's 3 convictions for the assault and battery by means of dangerous weapons against Kristen and Robert Fuller, and for the first-degree murder of Ronald Pratt with both deliberate premeditation and extreme atrocity and cruelty. I want to note at the outset that on both theories of this case, a person with a grudge against Ronald Pratt was responsible for all of the bloodshed and all of the violence that occurred at the same outdoor encampment in Weymouth on the evening of July 18th and in the early morning hours of July 19th of 2009. Had the defendant timely appealed the denial, again, without prejudice, of his most recent 278A motion by the trial judge, here the trial judge correctly would have found that his submissions failed to supply information supporting all of the Section 3 factors. And
Really,
here,
it's a low bar, isn't it? I mean,
it is a low bar, Your Honor, but it is a bar because the defendant's motion in this case, he has never sought any more discerning or markedly more discerning testing than was available to him and to his own ex parte DNA expert, Dr. Ladd, for years before trial. He does not dispute that he could have sought this. And his motion makes it explicit, page 188 of the record, you'll see how he lays it out. He lays it out as basically an automatic entitlement. He's seeking the testing only because he chose not to test it and was convicted nonetheless. Quoting his motion.
so isn't he relying on 3B5?
He is, but but to get there.
Basically, we're putting the predecessor counsel to the sword here, right? That, given the overwhelming evidence here, you needed to pursue every possibility, even if it was a dangerous one.
Well, but that is the case here, Your Honor. I think on the record, and the trial judge certainly was extremely familiar with the record and also with the nature of the defendant's defense. And there are multiple, I would suggest that 3B5 is not the only, 5B is not the only element he failed to make a showing on. His motion sought, in his words, he wanted the testing because no items of biological evidence that were collected at the campsite were tested. He wants it to be automatic. The statute unambiguously says that it is not, that the defendant has to at least produce this information on Section 3 to get to a Section 7 hearing. And it's a denial, again, without prejudice, but I would suggest there's more than one factor he did not meet. He did not present He did not point to the existence of specific facts as this required in Wade and Donald and all the cases on point here. And that starts at the factual
Really,
threshold.
you seem to be stuck with like a 128 from the appeals court, because all the other cases seem to generously allow this kind of testing, because we sort of the last double check that we haven't got the wrong guy.
So Your Honor, I would say that actually this is cases like Linton and Moffett are very much on point here in showing
But
the deficiencies. in the
Counsel,
proof.
aren't those cases Section 7 cases? That is the defendant in those cases got the evidentiary hearing pursuant to the threshold showing under Section 3?
I believe Donald too is not. Well, if I may sort out the Section 3B5 from the other elements here. The statute, of course, does not provide for automatic testing because it wasn't done. One thing it is not is a do-over. It provides at Section 3 an essentially limitless mechanism for a defendant post-conviction to make the sufficient showing. It starts out in its insufficiency at the threshold. I think it is not insignificant that none of the defendant's motions, none of his affidavits has averred innocence as to 2 out of 3 conjoined crimes resulting at bloodshed and the shedding of biological evidence all over this outdoor scene. And because of that, the trial judge would have been aware, unlike another judge, she would have been aware of this factual context for the biological evidence there. And he could not have averred innocence to those 2 crimes because, as his affirmative defense at trial revealed, he conceded his identity at the crime scene. He conceded his identity, so only there's a limited universe of people. There are 5 people at the crime scene when the first two acts, sustained acts of violence involving the entire people present at the crime scene take place. 5 people, 3 of them live there and obviously have shed biological material there. On the defendant's own defense, Mr. Pratt and Mr. Fuller were involved in a previous bloody attack with a hatchet at the same place just a couple of weeks earlier. That is, in fact, what the defendant contends is Robert Fuller's motive against Mr. Pratt for all of this violence, in his argument that it was actually Robert Fuller, not the non-present Royal or anyone else non-present when the 5 of them were there that night on July 18th, who was responsible. And because his defense and the uncontested facts conceded the defendant's identity at the crime scene and the absence of third parties other than those 5 people, he could not have shown it was material under Section 3.4. So that's another absent showing here. Because there was no evidence that the killer contributed any blood to the scene for the same reason. This was a bladed weapon in the dead of night when all the evidence was that once Mr. Pratt was unprotected and had gone to sleep in his tent in layers of clothing, where he was stabbed to death in unquestionably a blitz attack by someone who brought a knife back to kill him, to stab him 46 times in his tent. There was no indication that either when killing Mr. Pratt, the killer touched him, or that Mr. Pratt touched his killer, let alone that the killer would have shed any blood. So on that point, and going to the soundness, the objective soundness of defense counsel.
How do we know? How do we know that? I mean, if the blood were actually tested, we might know. We don't know what happened in that tent, do we? We don't know the details of the murder because no one observed it. One person, the victim is dead. and no one tested the blood, for all we know, there could be all kinds of different people's blood in that tent, right? We don't know whose blood it is.
Your Honor,
And
but
we don't know if
that's
there was,
part
we
of
don't
why.
know if there was, we don't know if there's resistance either, do we? I'm
I
not saying this
think
is a
there's
strong case for the
no evidence
defendant,
that
but
there was resistance.
Your Honor's
And if there was
speaking.
resistance, there was no evidence. I think it's significant there was no evidence. So this takes place inside a tent. The evidence is there's going to be Robert Pratt's, Robert Fuller's, Kristen Fuller's, Mr. Estabrooks. The only biological material we would not expect to find outside the tent or on shared items or on items down a blood trail would be the defendants. My brother's assertion to the court this
Well,
morning that it would not have harmed his cause.
Again, how do we know these? You know, it's one thing when you test it, but when you don't test it, it's a little, you're certainly in the light most favorable to you. That's absolutely true. But that's not how we do these things.
And counsel, could I just follow, counsel, could I just follow up on Justice Kafker's point?
Yes.
Because my muscle memory is still too much as a trial judge with these type of things. But wouldn't you want to know, as the government, wouldn't you want to know the answer to this question? I mean, if you follow up on in the extension of Justice Kafker's point, there's all this DNA, all of this biological stuff. Pratt may have an axe to grind, a dog in the fight. I understand that it's this encampment and lots of people kind of traverse through it. There might be all types of things here. But considering what we're talking about here, wouldn't you want to know?
Your Honor, the thing is, there is all kinds of blood and biological material at the scene, but there's no fact that would lead to the conclusion that the assailant's blood would have contributed to the blood at the scene, just as in Sastry and Donald too, just as in those cases. And the thing is, this was certainly known to the defense and was the core of an objectively reasonable strategy not to conduct any testing. The defense DNA expert was present at the only exhaustive testing that was conducted in this case. So it is the defendant's burden to show that that objectively reasonable counsel would have chosen to do it. And there are many reasons why objectively reasonable counsel, it cannot be said that objectively reasonable counsel would have chosen to test items at the scene. I point, for example, to my brother's argument that it wouldn't have mattered if the defendant's blood or biological material from him, say wearer DNA on a sock, something like that, were found on the trail down to Washington Street through the rear of the campground. It would have been devastating to the defense. And certainly reasonable counsel, objectively reasonable counsel would be in a position to know whether to risk that testing, because the defendant drove in and out a different way on his SUV. He emerged at 2 o'clock in the morning and encountered Officer Malloy, shirtless and uninjured, with dried blood on his hands, immediately downhill of the murder scene. If indeed there were wearer DNA of the defendants on clothing, cast off or some combination of cast off blood from Ronald Pratt, who was bleeding copiously to death just uphill, that would have been devastating information.
Can I ask about the other?
Objectively.
Can I ask about Fuller? So the
Yes.
earlier fight takes place when? Sorry, I just put.
The earlier fight takes place on the evening of July 18th at the campsite, where initially Lambert Estabrooks and the defendant were visiting their old friend Ronald Pratt at the scene. Then at some point, Lambert asks the defendant to drive him home to his nearby apartment.
I'm just trying to get the difference between the timing. So the beating of the Fullers, which the defendant is also done, right? am I misremembering? The defendant could very well have the Fullers blood on him at that time too, right? When he's
Absolutely. In
got
fact,
blood on.
Yeah,
ahead.
yes, Your Honor, the defendant, in fact, it was the nature of his defense that he and experts were responsible for Mr. Fuller's injuries, but actually that the defense was that Mr. Fuller was responsible for his own copiously bleeding injuries at that time, because it was the defense theory of the case that Robert Fuller was initially going then after Mr. Pratt, but that the defendant and Mr. Estabrooks intervened. I'm sorry, I skipped a sequential motion there in that Lambert was not there when the imbroglio, initial violence occurred. Lambert had asked the defendant to drop him off. So it was just the defendant and Estabrooks, and the defense was that justified use of self-defense against Robert Fuller in the initial violence. And then the defense was essentially then when Mr. Pratt was unprotected, asleep in his tent, he was the subject of the blitz attack, the murder later that night, and then officer and
Am I
in
right?
between.
Am I right on
Sorry,
the stakes here? Say we think, again, say we think, it sounds like you're backing off of the notice. Have you given up the whole argument about notice now that the opposing counsel said, I never got any notice? Or are you giving up the timeliness argument, or where are you on that?
Absolutely not. I gave up nothing, Your Honor. I think it's a jurisdictional defect under an unbroken line of cases of this court.
If the court forgets to give notice, let's take a different case.
Your Honor, there is nothing in the record that supports the claim that the defendant.
Okay, so
This was an
essentially-
expedited hearing at an expedited motion on the calendar on the defendant's request to precede the receipt. He asked for another extension of time after all these years to file his.
Okay, can I ask you, did you get notice?
I absolutely did.
You got a
Absolutely
timely
did.
notice, and
it
that's
was
in our
the-
record. It's in our record that you got a
it's-
timely notice.
And it is docketed in the court as timely notice. And moreover, when this court gave the defendant leave to appeal, or the Commonwealth, we might not have prevailed. It gave the aggrieved party a leave to appeal and have that consolidated in the direct appeal. It also issued another order that the defense filed. It was his motion to check upon, and gave another order that he filed status reports, which would presumably have called upon him to consult the record on the disposition of his own motion. But there's certainly no basis.
My last question is, again, are the stakes here, am I correct on what the stakes are on this Rule 3 issue? Meaning you can win this entire appeal, but if you're wrong on the Rule 3, all we're talking about is testing of those materials and the shoe expert. That's all that's at stake here, right? Is that more or is there a danger that the whole appeal has to be, that everything falls apart here?
Well, I suppose in theory that this court can find that any aspect of this case on 33E review caused a substantial risk of a miscarriage of justice. I think in this case, my understanding would be that the outcome were this court persuaded that the trial judge erred in denying this without prejudice, that he could, without that, go back without prejudice and try again under Section 3 and submit a showing addressing the trial judge's concerns here. But at most, I suppose it would go back to the trial court for a Section 7 hearing, at which the defendant would have the obligation to meet much higher burdens of proof and on the same and additional factors, which are issues here. Does that answer your question, Your Honor?
Yeah.
I had just very briefly, because I don't like to consume all of my time on the 278A issue, but I want to stress that this was a very well thought out defense. I mean, the issue for the defendant forensically was not that there was anything that incriminated him at the scene forensically, that there was not a forensic link to him in any item at the crime scene. He certainly could have conducted testing had he reasonably believed that that would be the case. The problem for him was that there was forensic DNA testing done outside the crime scene where on these facts, the Commonwealth considered it probative, including the presence of Ronald Pratt's blood DNA profile in a watered down blood stain on the top of the defendant's right shoe, or at least the shoe in his size that had what jurors could have concluded was the defendant's wearer DNA profile retrieved from the defendant's SUV within fewer than 24 hours, which was towed within fewer than 24 hours of all three violent crimes. So that was the issue for the defense. And given that, that was yet more reason for the defense to go to what it did here, which was a core Bowden argument that independent pretrial testing might very well have negated. It not only would objectively reasonable counsel not have risked creating that first instance forensic link between any item at the crime scene and this defendant, but this was the core of the Bowden argument that trial counsel, and I think experienced and objectively skillful trial counsel here made to the jury that in closing, and that the jury was instructed upon very much to the defendant's favor. And he argued that that the Commonwealth had drawn this magic circle around the crime scene, had tested items elsewhere, but not there. That was extremely favorable on the defendant's theory of the case and his argument to the jury. And that helped essentially divert their attention from the fact that the murder victim's blood profile was found elsewhere on the defendant's shoe. So in that case, it would have where the defense's argument was that it was outrageous of the Commonwealth not to have done that testing. And the trial judge gave explicit instructions on that point, permitting the jury to consider that as reasonable doubt, as deficient, and particularly not having done testing that if the jurors thought it should have been done. That was before the jury. That was the core of the defense. That was what reasonable counsel risked torpedoing had he either conducted the independent testing that was available to him or tried to, there's no other defense. There's really no other defense on these facts to the forensic evidence from elsewhere.
Counsel, thank you. Your time is up and we'll take the rest on the brief. If that's okay, all right?
Thank you very much, Your Honor.